Hello students and welcome to the lecture. So students, as we know that we are covering the general awareness, and for last few lectures we have been covering on the civics part. Okay, and basically to give you the little bit revision type, you can say, basically we have started the discussion over organs of central government, right? That's what we are discussing. All right, and basically we had come to know that when we talk about the organs of the central government, basically there are three organs. First is the executive part, there is legislature, and the third one is judiciary or judicial, you can say. Okay, so basically these are the organs which we had seen in the starting of this series, and basically we had finished executive part, in which we had discussed in detail about the president, vice president, prime minister, council of ministers, as well as the attorney general and the special provisions granted to the MPs, member of parliaments, and other things. Okay. Thereafter, in the last lecture, we had finished the legislature part. Okay. In the legislature part, we had discussed various things in details about the parliament, right? What is the Lok Sabha, what is the Raj Sabha, okay, and what are the different provisions associated with them. We had finished this thing, okay, and right now we are going to start the judiciary part, okay. So before this, let us make the cycle again. So basically, we had made a cycle in the previous lectures. It's a legislature, it's the executive, and this is the judiciary. Okay. So now it's the time to discuss their functions. First is the legislature. What legislature does? They make rules and regulations as per demand. Okay, demand means demand of the people or demand of the time. Whereas executive, they are in charge of implementing the rules. Okay, judiciary. What's the role of judiciary? They ensure proper implementation as required. Got it? So these were the three works which we had discussed, and I have shown you here also so that you can revise it. Okay. Now, I think it's a good recapitulation which we have done right now. General awareness, we are covering civics series. This is the topic we are going to start in these lectures. Okay. So as I have told you, we are going to cover the judiciary part. Okay. In judiciary, basically we divide the judiciary into the three segments. First is the Supreme Court. It is the national level judiciary authority. It means that everything which comes within the territory of India comes under the jurisdiction of Supreme Court. Okay. Thereafter, we have the High Court, contain respective state. Okay. And thereafter, we have the subordinate court, contain, okay, contain respective district. Alright, Supreme Court is on the national level, High Court is on the state level, subordinate court is on the district level. Okay, and if we check the hierarchy, level, then basically this is the hierarchy. Supreme Court is on the top. There comes the High Court. And then comes the subordinate court. Okay. So this is the flow like this. Got it? Supreme Court top, High Court second, subordinate court third. Alright, so let's begin. First we have the judiciary part. Sorry, Supreme Court. Okay, judiciary third because first executive, second legislature, third judiciary. Okay, so the first is the article number 124. It stands for the establishment and constitution of Supreme Court. Okay, this article establishes the Supreme Court of India comprising a Chief Justice and number of other judges as may be determined by the Parliament. Okay, judges of the Supreme Court are appointed by the President of India and must have served as a judge of High Court for at least 5 years or an advocate of a High Court for 10 years or be a distinguished jurist in the opinion of the President. The article also outlines the procedure for the appointment of judges and conditions under which they can be removed. Okay, so basically if we discuss this thing in the points, first we can say the head of the Supreme Court is Chief Justice of India. Okay, he is the senior most judge of the Supreme Court and he also administered the oath of the President. Remember, I had told you. Okay, then comes the second conditions, which is the eligibility criteria. Okay, first must be an Indian citizen. Okay, second judge of High Court. For 5 years. If was not a High Court judge, then must be an advocate of High Court for at least 10 years and then must be an distinguished jurist in the eyes of President. All right. Thereafter, if you remember, we had this one. Judges and the strength of the Supreme Court is not fixed, but it's depend upon the Parliament and the Parliament has the right to increase or decrease the, only increase the size of the Supreme Court. Okay, the government could not curb their powers, curb their jurisdiction, curb their strength, but can do the opposite. It means increase the power, increase the jurisdiction, increase the strength. Got it? They are appointed by the President of India. Okay, and this also outlines the conditions in which they can be removed. All right. Thereafter, we have the article number 125. It stands for the salaries and allowances of judges. Okay, it specifies the salaries and allowances of the judges of Supreme Court. These salaries and allowances cannot be varied to their disadvantage after their appointment except during a financial emergency. Okay, it means that suppose that fellow is the judge of Supreme Court. Salary promised to him was 2 lakhs per month. Again, I am not claiming that this is the exact salary we pay to the judges, but it's just an example and estimate, so do not take it as serious as. But just try to remember it. Okay, so it means 2 lakhs per month the salary was promised. Once the judge has been appointed, this could not be reduced. It means there could not be change in the salary once the judge is appointed, except the condition of Article 360. Why 360? If you remember in the previous lecture, I had told you 360 stands for the financial emergency, right? So during the financial emergency, this salary could be reduced, but except the financial emergency, there is no change could be made in the salaries of the judges once they got appointed. All right, as per the Article 125. Okay, now let's move forward. Then we have Article 126, appointment of acting judges. Okay, when the office of the Chief Justice of India is vacant or the Chief Justice is, by the reason of absence or otherwise, unable to perform the duties of the office, the President can appoint the senior most judge of the Supreme Court to act as the Chief Justice of India. Alright? It means that in the some special circumstances, if the Chief Justice of India is not available and is not able to perform the duties, in such a cases, it's depend upon the President of India that he could appoint any other judge to act as the Chief Justice of Supreme Court. Okay, and this designation is known as the acting Chief Justice. Okay, thereafter we have the Article 127. 127 stands for what? It stands for ad hoc judges. Okay, it stands for ad hoc judges. Okay, what do you mean by ad hoc judges? Let's understand. In the case of a lack of quorum of the permanent judges to hold or continue any session of the court, the Chief Justice of India can, with the previous consent of the President, request a High Court judge to act as an ad hoc judge of the Supreme Court for a temporary period. Okay, for example, just take an example. Suppose, basically, we have two types of benches in the Supreme Court. First is the constitutional bench. Okay, thereafter the regular bench. Okay, and the third condition is the committees. Okay, so if we go with the first bench, it's the constitutional bench. In constitutional bench, there is a requirement of 5 judges. Okay, thereafter the regular bench. In regular bench, there may be 1 judge also. Okay, thereafter the committees and number of judges could be included. There is no fixed criteria that this must be the number. Any number of judges could be included in the committees in order to investigate or give the suggestion or review anything. All right. So in such a cases, suppose the condition arises that the Supreme Court do not have a sufficient judging staff with itself so that the Supreme Court could adequately maintain the 3 branches. Okay, and it is a need of a time that they required a staff. In such a condition, they could not appoint anyone to be as a judge of the Supreme Court. It requires a time to be got appointed. All right, that's why in such a condition, to fulfill this kind of urgency, the Chief Justice of India, having the power that with the prior consent of the President, he could appoint any High Court judge as an ad hoc judge. Okay, to act as a Supreme Court judge for a temporary period. Okay, so in such a condition, when the Supreme Court is running short of the judicial staff, the Chief Justice of India, with the prior permission of the President, could appoint any judges of High Court to be the part of any of this and act as an ad hoc judge. Okay, for the temporary period. All right. Thereafter, we have the article number 128. All right, it is the Attendance of retired judges at sittings of the Supreme Court. This article allows the Chief Justice of India to request a retired Supreme Court or High Court judge to sit and act as a Supreme Court judge. Alright, with the President consents, such judges have all the jurisdiction, powers, and privileges of a Supreme Court judge but do not otherwise hold office. Got it? So basically what happens, suppose this is the another condition. In such type of conditions, the Supreme Court is facing the shortage of the staff. Alright? And in such condition, the Chief Justice of India could appoint the retired Supreme Court or High Court judge to sit and act as a Supreme Court judge, but only after obtaining the permission from the President. Alright, this condition has been described in the Article 128. The person who has been appointed to act as a judge of the Supreme Court will have the jurisdiction, powers, and privileges of a Supreme Court judge, but do not otherwise hold office. Got it? Then we have the article number 129. 129 stands for what? The Supreme Court is declared to be a court of record, which means it records are recognized as legal evidence. It has the power to punish for contempt of itself. Alright? It means that whatever the ongoing proceeding is in the Supreme Court, whatever the discussion has been held, and what is the discussion which is going on or will be occurred in the upcoming time, all these kind of things has been recorded and properly maintained in the court. Alright? So if anything has been ordered by the court and the thing has not been done in such a condition, the court could use the record as a legal evidence against the person who is not obeying the orders, and court could punish him as the contempt of court. Alright, so remember this thing. All the proceedings listed in the court properly. Okay, if the order has been granted and it's not obeyed or fulfilled by someone, then the court could use that record as a legal evidence against that person, and on the basis of this recording order, the court could punish the person as the contempt of court. Got it? Thereafter, we have the article 130. Okay, it's for the seat of Supreme Court. Principal seat of the Supreme Court is in Delhi, but the Chief Justice of India can, with the President approval, appoint other places as the seats of the Supreme Court. Okay, so basically, if we talk about the Supreme Court seat means the Supreme Court is situated in New Delhi. Okay, it means that any proceeding of the court, Supreme Court, could be held only in the New Delhi, because all proceedings only in the New Delhi. Why? Because this is the official seat of the Supreme Court. Alright, but the Chief Justice of India, or in short you can call them CJI, Chief Justice of India, okay, with the prior consent of President, could request the President and take the consent and declare any other judicial authority or place which is not lying in Delhi but lying outside the Delhi as a seat of the Supreme Court under the article 130, but only after obtaining the permission from the President. Okay. Thereafter, what we have the article number 131, original jurisdiction of the Supreme Court. Okay, this article gives the Supreme Court original jurisdiction in any dispute involving the government of India and one or more states, or between two or more states. You can say three conditions is there: center and state, or you can say there is a condition between center versus state. Okay, then center versus states, more than one states. Third, state versus states. Okay, if any of these three conditions arises, there is a dispute between center and state, dispute between center and states, dispute between state versus state. In such a condition, there will be a jurisdiction of Supreme Court which matters. All right, and this is given by the Article 131. All right, and it is known as the original jurisdiction. Okay, thereafter we have the Article 132. All right, it is the appellate jurisdiction in the constitutional matters. All right, it provides for the Supreme Court's appeal jurisdiction in the cases where High Court satisfy that these cases involves a substantial question of the laws as to the interpretation of the Constitution. Okay, if you watch movie, web series, and whatever other media, you must have come across a fact that if someone loses the case in the subordinate court, high court, or whatever court, then they always claim that they will challenge decision in the Supreme Court. What does it mean? It means that if we make a chain, Supreme Court, High Court, okay, subordinate court, then except the fundamental rights and the special circumstances, the person who has issues with the laws could not reach High Court and Supreme Court directly. Okay, again I'm mentioning, if this is a case of fundamental rights and some special case, then only the person is allowed to visit them, but otherwise no. Okay, so first the case will be in the subordinate court, then the case will be in High Court, and then the case will be in Supreme Court. For this kind of conditions, you have to appeal in the upper court. If you loses the case in here, then you have to appeal to the High Court. Then if also again you loses here, then Supreme Court. Okay, so that's why it is known as the appellate jurisdiction. But there is a one condition. What does it condition? If the person reaches the Supreme Court and appealing the case and appealing the court to take over the case from the High Court and then review it and then give the new jurisdiction. In such a case, High Court is required to satisfy that the case involves a substantial question of laws as to interpretation of the Constitution. Okay, if this is the condition, then only the Supreme Court will take over the charge. All right, remember, this has been promised in the Article 132. Got it? Moving forward, now we have the 133. Okay, 132 is for the constitutional matters. All right, whereas 133 is for the civilian matters. Okay, appellate jurisdiction in civil matters deals with the appellate jurisdiction in the Supreme Court in civil cases, granting it the power to hear appeals from the High Court. All right, in such a cases, High Court certification is generally not required. All right, thereafter we have the 134, article number 134, appellate jurisdiction in the criminal matters. All right, this article outlines the circumstances under which the Supreme Court can exercise its appellate jurisdiction in the criminal proceedings. All right, it means that if the case having the criminal case nature, like a murder, robbery, and whatsoever, okay, in such a condition, if the person wants to challenge the decision of the subordinate court or the High Court, mostly the High Court, because subordinate court does not provide a opportunity to reach the Supreme Court directly unless the fundamental rights and special cases. But subordinate court, High Court, then Supreme Court. So mostly we have to deal with the High Court. So if there was a decision of the High Court which is not lacking by any party of the case which having the criminal nature. Such a condition they could apply in the Supreme Court, and by the virtue and by the power of Article 134, the Supreme Court will take over that case. All right. Thereafter, we have the Judiciary, Supreme Court, 135. Article 135, Jurisdiction and Powers of Federal Court. Federal means, basically, remember I had told you one thing. When we divide the government into three parts, and you can say the Indian government can be divided into three parts. Central government, state government, and thereafter local government. Okay, highest level, second highest, lowest level. Okay, so the federal is basically means by this. When there is no concentration of power, it means central government does not have any power, but they have to distribute it amongst the state and the local government. Okay, that is the case of federal. Allows the Supreme Court to exercise the same jurisdiction and power as the Federal Court of India under any existing law. It means that Supreme Court could interfere in the matters of High Court and the subordinate court if the question is having the great and utmost importance to the law and constitution as well as the society. Okay, by the virtue of Article 135. 136, special leave to appeal, provides the Supreme Court with discretionary power to grant special leave to appeal against any judgment, decree, determination, sentence or order in any case or matter passed or made by any court or tribunal in India. It means the power of repealing. Got it? But except the cases of military court or court martials, you can say. In the case of military court and the court martial, the Supreme Court could not grant a special leave to appeal. This belongs to the pardoning powers of President. Okay, remember this thing. 137, review of judgments or other orders, authorizes the Supreme Court to review any judgment pronounced or order made by it, subject to the provisions of any law made by Parliament or any rules made under Article 145. Then the Supreme Court could pass the review judgments or orders. Thereafter, we have the Article 141, law declared by Supreme Court to be binding. Okay, declares that the law declared by the Supreme Court shall be binding on all courts within the territory of India because it is the federal court and the supreme authority or judicial authority within the Indian territory. Alright, that's why the laws prescribed by the Supreme Court is applicable in every court. 142, enforcement of decrees and orders, empowers the Supreme Court to pass any decree or to make any order necessary for doing complete justice in any case or matter pending before it. Alright. Thereafter, 143, power of President to consult the Supreme Court. Okay, it means that under the 143 article, the Supreme Court could provide the advices and give the consultancies to the President if required. Okay, gives the President the power to seek the opinion of the Supreme Court on questions of law or fact of public importance. Okay. So basically in this lecture, we have done with the Supreme Court. In the next lecture, we will finish with the High Court or the subordinate court. Till then, just revise all the articles and facts and figures we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and